ensures that the judicial branch shall be insulated from not only the executive but also legislative intrusion. Okay? So, conferring the power to the Supreme Court means that I, insulation has to be maintained. Now, once you confer the power on the Parliament to override those rules, that insulation goes. Because, as it was argued yesterday, or at least it was observed yesterday, this is an intrusion into the autonomy of the Supreme Court, which is the main theme of the Constitution.
May I address this question when I deal with the relationship between the Act and the rules? Which will prevail in what circumstances? Because that is what you're...
Ye jo amendments hain, do they or do they not interfere in the internal working of the Supreme Court?
Sir, the criterion is not whether they interfere in the internal working of the Supreme Court.
That is the criteria
I'll
of
show,
independence.
No, my lord, I will say there are 4 restrictions on Parliament as far as its legislative authority is concerned under Article 191, read with entry 4. Let me first state that, then I'll explain. The first restriction is that under 191, only a law relating to practice procedure can be made. The second restriction is that Parliament can make no law, whether it's internal working or otherwise, which violates the principle of the constitutional principle of the independence of the judiciary. Number 3, and this might answer your lordship's question. Parliament cannot legislate in a way that it colonizes the power of the Supreme Court to make rules or destroys the power of the Supreme Court to make rules. It's a supervisory power. It's a checking power. It's not a power which can destroy the Supreme Court or paralyze the Supreme Court into making rules. And I think the fourth is that entry 55 and 58 still have to be read harmoniously. Parliament cannot make rules which in any way affect the jurisdiction as well as lessen the power of the Supreme Court. So these are the 4 restrictions on Parliament's powers.
Doesn't the Act affects all those 4?
I will show to your lordship it doesn't.
That you have just spelled out.
I will show to your lordship it doesn't when I come to each provision of the law. So these are the 4 restrictions. I'll elaborate on this, sir. But let me
answer the initial question.
Yes.
Does it constitute interference in the working of the Supreme Court?
Sir, I think...
Yes or no?
Sir, I would rephrase the question. The relevant question is, does it interfere in the internal working of the Supreme Court to the extent that it affects the independence of the judiciary?
Now,
That's the question.
You used the word supervise.
Yes.
Isn't supervision have an element of control?
Any supervision will have the element of control, but control does not mean, regulate does not mean that you destroy the power.
How can you control without interfering?
No, any supervision will imply interference. The question is, does it colonize the other person's power? Does it destroy the other person's power? Does it violate the principle of the independence of...
Where the Parliament has made a law that destroys the rules, what does it do? It destroy.
It doesn't destroy the existing rules. Now that is a question which I will address. Relationship, अगर मैं सिर्फ competence अगर खत्म कर लूँ अपील की हद तक, मैं अपील की हद तक क्योंकि I've
एक question मेरा जरा add कर ले छोटा सा.
जी.
Article 191 says subject to the Constitution and the law. So what does that mean? The powers given to the Supreme Court by the Constitution are absolute, or is there still a room for interference? Interference means amendment or...
I would not like to use the word interference because it gives...
It's not interference, yes. I'm sorry for that.
I would say that your lordship...
But still the rules are, the power which has been given to the Supreme Court, is that power absolute?
No, it's not absolute.
Because the first word is subject to.
Yes. Subject means conditional. It is a restriction. It can't take over the power to take rules. It can't paralyze that. That is why I would say that the Supreme Court should be insulated from external pressure. It should not be isolated. So Article 191 creates this balance where the internal autonomy of the Supreme Court stays in the hands of the Supreme Court, but subject to certain restrictions which may be imposed, and certain conditions which may be imposed by Parliament. I'll come to, because this is a crucial question, and there is a Supreme Court judgment on this, the relationship between rules and act and what prevails. I'll come to that.
If I've understood you correctly, what you're saying is that this is not this law-making power or law as in 191 is not a fully enabling power, but it is a power of a supervisory nature. Is that what you're saying?
It is a restrictive power.
You use the word supervisory.
Yes, I use the word supervisory in terms of that it is a power which has its limitations. That is why
That was the reason, one reason why I'm asking this is because you're emphasizing on linking this with entry 58.
Yes.
Which you say should be interpreted in the usual way that the legislative entry is normally interpreted.
Yes.
That would seem to necessarily imply that whatever is the subject matter of that legislative entry, which is not as such disclosed in 58, but I imagine would then be the practice and procedure of the Supreme Court, then surely if you read it the way you are linking it, then that would, the law-making power would cover the whole of the field of the practice and procedure of the Supreme Court, and thereby, just hang on, thereby become an enabling power and not remain a supervisory or restrictive power of the nature that you are now stating. So there is this tension between what you are saying, a possible conflict. Kindly clarify this point.
My Lord, there is no conflict because the language of entry 58 clarifies. Entry 58 cannot go beyond the conferment of power with necessary implication which any article of the Constitution does. So any power in terms of legislation which entry 58 does must be in the context of the power conferred by the Constitution. So if 191...
But that power, in the end, legislative entries confer power, legislative competence over a subject matter.
Yes.
A tax on income.
Yes.
The defense forces, international relations, what have you. The entry 58 of itself discloses no subject matter as such. It simply refers, because this is the point
that is why it is limited by that constitutional provision which confers this power.
Then how do you read it as a legislative entry? Because if you now link it to the subject matter of practice and procedure, that then should
Sir, if you don't read it as a legislative entry, you will make part of the entry redundant. The part of the entry says or relate to the federation.
And that's what I'm saying. That
I mean, it makes it redundant.
No, it doesn't make. That's my question to you.
Yes.
Aapki jo submission hai,
Ji,
mujhe samajh aa rahi hai.
I'm sorry, sir.
That seems to me not to be restrictive or supervisory. That would necessarily, if you link it to a legislative entry and the manner in which legislative entries are interpreted, that would have to be given the legislative competence, the power to make the law, the enabling power, whatever you want to put it, would, it seems to me, have to be interpreted in the broadest possible manner, which would mean that it would cover the whole of the field of practice and procedure, which is why Mr. Salahuddin, for example, said that yes, the Supreme Court rules can be repealed by an act of Parliament.
No, I don't take that.
Don't go there.
No,
I understand.
I don't
That's why I'm asking you.
Yes.
So there is this tension
Yes.
between linking it to a legislative entry, because that's how legislative entries are interpreted, and then in the same breath or in the next breath saying that no, it can't go to the full subject matter. It is restricted to supervisory or limited nature.
My Lord, these are entries which I call ping pong entries, and I'll explain when it comes to...
Mr. Faisal, taking the discussion further, and that's very important, what's being discussed. My understanding is, what appears to me so far is that when we have to read 191, straight away when you look at 191, there could be a restrictive meaning given to law, but we don't have to really stop there. We could also say that there could be a law, even plain reading of 191, that there could be a law that would cover the area of practice and procedure, because that's why to that law. There is a law, whenever Supreme Court goes ahead and comes up with rules, it will look at law. There could be laws relating court fee, there could be laws relating to many things that impinge upon, but at the same time there could be a law which takes care of the whole area of practice and procedure. But when you read it with 58, it does, as my learned colleague also mentioned, it says that it covers, it is the subject matter that we'll have to look at. And it appears that when 191 is read with 58, the entry, it appears that there is a legislative competence with the Parliament to legislate on the question of practice and procedure. So hence, perhaps what Mr. Salahuddin said, that it can abolish the Supreme Court rules, appears to be then correct. You can't stop halfway. You have to either accept the whole contention saying that 58 read with 191 gives the legislative power, and then in that case they can go ahead and do whatever they want to do regarding the rules. So that's one. So, but what appears to me is that if 191 is read after reading 58 and you come back to 191 after reading 58, then you look at the legislative competence only, and it appears that then law, when you look at law then after 58, it appears that it gives you that legislative competence.
I bow to your lordship. That is why I said it's a ping-pong entry, and that is what happens when you look at entry 55. My position is very different from Mr. Salahuddin's position.
Ping-pong can go on endlessly. Where does your ping-pong end?
I
think it's just one way. It doesn't go back again to the entry
One
again.
thing would do.
But one more question that I want to add here, maybe you can respond to that also. Is there a difference between the word practice and procedure? Because one would understand that it could be a procedure of the Supreme Court. What's the importance and significance of the word practice? And I say it for a reason. I say it for a reason because there are judgments of the Lahore High Court while discussing letters patent, saying that this is an internal arrangement in the, they don't consider it as an appeal. They consider it as an internal arrangement of the court, as if it were to pass for a practice. So considering that case law, written by celebrated judges of our courts, the question is, could it then be said that considering that it's an intra-court appeal, it's not an appeal in the appeal sense. That's exactly what the judgments say. It's not an appeal, it's an internal arrangement of the court. Could it then pass under the term practice under 191 to have this intra-court appeal? As you had mentioned earlier, so that's why, is there any significance of the word practice and whether intra-court appeal passes for an internal arrangement of the court and not to be considered as a substantive separate appeal?
My lord, this is a question which to a certain extent has been answered by an opinion of Justice Munib. And I'll straight away come to that. Those are three. There is a short order by Justice, it is Justice Mandokhail who actually raised this very important issue through a short order. And then there are two opinions, one by Justice Hassan Azhar Saab, one by Justice Munib.
You might consider these three judgments of the Lahore High Court.
Yes,
also,
I can. But let me just read those, because those are actually with reference to this particular case, if I may come to those judgments. And those deal with both issues, one of competence of appeal and intra-court appeal. Both have been dealt by the two separate opinions. If your lordship will kindly see
that, that was without my opinion. Without my opinion.
लेकिन सर आपके सवाल की वजह से डिबेट शुरू हुई. आप सवाल नहीं पूछते.
Actually, this should have been that I should have been asked, what is your opinion? Without my opinion, it was said to.
लेकिन सर आपके खिलाफ जवाब देके भी आपके हक में जवाब दे दिया, वो देखिएगा आप जरा पेज 9 पे.
चलो मैं उसका जवाब अभी जो खत्म होगा तो उसमें दे देंगे.
Sir, page 9 of the paper. Now, these are three unreported orders, my lord, but I think these are such crucial orders should be. If I may first to Justice Mandokhail's very interesting question, which he's been constantly raising in these proceedings. If I may come to page 9, and I'll read from the second paragraph, para 2, fifth line. The question which needs consideration is whether a remedy of appeal could be provided to an aggrieved person either through an ordinance or parliamentary legislature in respect of matters decided under the jurisdiction conferred upon a court under Article 199 of the Constitution, Reference is made to the order dated 13/4/2023 passed in constitutional petition 9 of 20. This very petition, relevant portion whereof is reproduced above. I'll leave the portion. I'll read the last 4 lines. As the issue involved is in this petition is identical to the issue involved in constitutional petition number so and so, therefore let it be placed before the Honorable. Now, on this, a dissent was done by Justice Hassan Azhar Rizvi. Very interesting opinion, my lord, page 12, if your lordship may kindly see. Now, the main thrust of this opinion is on that this question did not arise in the case. That is why the case was really decided on the merit. There's a very important paragraph on this intra-court appeal, which is at page 17, para 14. It's the same it is the same line of argument which Justice Mazhar had alluded to yesterday. Para 14, page 17. As far as the question of whether a remedy of appeal could be provided to an aggrieved person either through an ordinance or parliamentary legislature in respect to matters decided under the jurisdiction conferred upon a court under Article 199 of the Constitution is concerned, so both constitutional forums, intra-court appeal in the law reforms order. I am of the humble opinion that Article 175 of the Constitution, by its clause 1, ordains that there shall be a Supreme Court of Pakistan and a High Court of each province, and recognizes that such other as may be established by law. Clause 2 of that article provides that no court shall have any jurisdiction save is or may be conferred on it by the Constitution or by or under any law. For the above question, it is sufficient to say that the Supreme Court of Pakistan and the High Courts have been established by the Constitution, that they have such jurisdiction as has been conferred upon them by the Constitution, that they have also such other jurisdiction as is or may be conferred upon them by or under any law. The expression law here has been used to distinguish it from Constitution, which is higher in authority and obviously means an ordinary or sub-constitutional law made in the exercise of the powers granted by the Constitution. Reference in this regard may be made to the judgment of this court in the case of Brother Steel Mills Limited versus Mia Ilyas Miraj, PLD 96 Supreme Court 543, wherein the provision of section 15 of the Code of Civil Procedure Amendment Ordinance 1980, which also provides a right of appeal to a bench of 2 or more judges of a high court from an interlocutory order made by a single judge, that court in the exercise of its original jurisdiction has been interpreted by a 5-member bench of this court. Even otherwise, no provision of the Constitution places such bar on the power of the legislature. Both under 199 and 184(3), there is no bar that a right of appeal through a statute cannot be provided. Now, your lordship may note 2 things about it, and I'll come back to this. The first is that legislative competence here has been placed on Article 175(2). That's the first thing. Number 2 is that it has been held that even if the order is from a, as Justice Mandokhail had pointed out, even court appeal can be provided through an ordinary statute. Now, it's very interesting how Justice Munib deals with this, because he extends the notion of legislative competence and agrees with Justice Hassan Azhar Rizvi on the issue of the law reforms ordinance. Page 20.
As a referee judge.
Ji?
As a referee judge,
Sorry? As a referee judge, sir. Page 20, sir. I may read. Para 3 measure of context de do. On hearing the matter, a different opinion arose between the learned members of the bench on a point that was, it appears, framed by Jamal Khan Mandokhail, his lordship, expressed doubt whether a right of intra-court appeal could be provided by ordinary statute, like the ordinance against a decision of a single judge of the High Court, exercising jurisdiction under Article 199. Reference was made to certain pending petition filed under Article 184(3) of this court. Now, let me come to para 4 a difference of opinion has, next page, has arisen in my view. The question of law requiring resolution is as follows. Can the appropriate legislature provide by ordinary statute for a right of appeal against a decision of a single judge of a high court exercising jurisdiction under Article 199 of the Constitution, such that Section 3 of the ordinance is a valid legislature? Now, as far as where does legislative competence come, or how is appeal in terms of legislative competence to be framed? Very interesting paragraph, para 9, page 23 of this opinion. If I may read kindly from the last line. One is a right, I move to the second page, that is relatable to a specific entry on a legislative, this is the next page, 24, or to a particular legislative
I may request you kindly start.
Should I read the whole, sir?
Provide
But sir.
Some background.
But of course, the ordinance was not just an amending statute. It also had Section 3, which provided as presently relevant for a right of intra-court appeal in terms as noted above. That also had to be taken into account when determining its spirit and substance on the commencing date. I begin by noting entry number 46 of the concurrent list. This provided in material part the legislative competence of jurisdiction and powers of all courts except the Supreme Court with respect to any of the in this list, all courts including the High Court. Right of appeal can for present purposes be divided into two categories. One is a right that is relatable to a specific entry on a legislative list or to a particular legislative competence. The other is what might be called a general right of appeal. Now, these are crucial lines. Now, it is well settled that a right of appeal is a substantive right which must be expressly conferred. However, jurisprudentially, appeals in a general sense are regarded as a part of procedural law. In my view, this categorization is relevant for purposes of legislative competence insofar as a general right of appeal is concerned. Such a general right would lie in the legislative competence relating, as the case may be, to civil or criminal procedure. This conclusion is bolstered by the fact that both entries relating to criminal and civil procedure, number 3 and number 2, and respectively, included therein all matters included in respective procedure code and CPC. Thus, entry number provided in material part as follows: civil procedure code and all matters included in the code of civil procedure on the commencing date. The two codes of course contain specific provisions by way of general rights of appeal. It may be noted that the context here is legislative competence. Therefore, what was relevant was not the type of appeal encoded in the Criminal Procedure Code and the CPC, but rather the categorization thereof in terms of their nature. Thus, a general right of appeal was included in the legislative competence conferred by these two entries of the concurrent list, my lord. So, what seems my reading is that as far as legislative competence is concerned, when you're looking at entries, then it is not a presumption that the competence to have a law on appeal would fall within a category which does not deal with procedure. It can deal with procedure. At least that is what it says.
Mr. Faisal, and I think that is echoed, you might not have looked at this, but I found 53 Lahore, 284, it's a DB judgment, and I just read this paragraph, which is important.
I found it very interesting, but I may be misreading.
Which actually talks about exactly something like this, which needs to be discussed, which is a letters patent appeal is not really an appeal in the strict sense. It may be more aptly described as an internal arrangement of the court for reviewing its own decision, given in the first instance by one member of the court. Then the first as well as the second decision remains the decision of the court. And if you look at Order 5 Rule 2 in the rules,
there's a chamber appeal.
There is a chamber, it doesn't say appeal, it says for reconsideration to a 3-member bench. So three judges. If you see Order 5, Rule 2. So, I mean, before going into 55, let's sort this out whether at all this could form part of having an
So
intra-court
no,
appeal.
Rule 3, Order 5, Rule 3 says appeal. Rule 3 says an appeal shall lie from registrar in all cases to
As
judges.
registrar,
From
agla pade na.
to the judges in chambers.
That's
It's an
right.
appeal.
And then there is from a single
That's
judge
an
to 3 judges.
administrative order, and that's an administrative appeal.
But it's still an
not
appeal.
a judicial order.
It's still an appeal and it's framed under 190.
Fair enough. I mean, it probably has a color, rightly said by my colleague, that it could be administrative in nature, but we need to understand the context. If you look at Order 5, Rule 2, it talks about the power of the court in relation to power.
In relation to the following matters may be exercised by a single
Can you
judge.
tell us where are you reading from?
Order 5, Rule 2, Order 5 says Supreme Court rules.
The power of the court.
The power of the court in relation to the following matters may be exercised by a single judge sitting in chamber, but subject to reconsideration at the instance of any aggrieved party by a bench of not less than 3 judges, which may include the judge who dealt with the matter. Your Lordship is right.
It refers to reconsideration. We don't know where to slot it. It is probably administrative in nature also. But what I'm trying to say is that intra-court appeal under these 3 judgments that I've looked at are talking about that it is an internal setting and a procedure and arrangement and not considered to be substantive in that sense, which has been echoed elsewhere also. Yes. So whether at all it becomes part of procedure of practice and procedure rather than as a substantive.
I think this note opens up that question. If I may just read the last paragraph and then your Lordship. Sir, as far as Justice Hassan Azhar Rizvi's opinion, which basically dealt with the merits of the case, and a paragraph on the intra-court level. There's a paragraph in Justice Munib's opinion on that, which is also very important. If your Lordship may kindly see page 25, para 12.
Para 12.
Ji sir, ji sir.
Ji.
Page 25. In view of the above discussion, I am in no doubt that the question referred to me ought to be answered in the affirmative. It is so answered accordingly. I also agree with my learned colleague Hassan Azhar Rizvi that leave to appeal should be refused and leave petition dismissed. उससे ऊपर जो है 4 लाइनें वो है in contrast. My learned colleague Sayyid Hassan Azhar Rizvi has rightly noted in an order. See para 15. Now para 15 flows from para 14, dependent on para 14. That despite lapses of more than 50 years from the promulgation of the ordinance, no such question called the legality of the ordinance has been raised by any party lawyer, any high court or this court, my lord. And para 14 dealt with 2 things. There can be an intra-court appeal from a constitutional judicial forum, and secondly, the legislative competence based on Article 175, sub-Article 2, my lord.
Okay, Mr. Counsel, the thing is that you are, of course, referring to my order.
Yes, sir.
It is an order of the court, and therefore it is for others to make of it what they will.
Yes.
It is not for me to now read and interpret it, but I am picking up on the point that you think flows from this order.
Ji.
Seems to me, you respect that it cannot conceivably flow from this order. The reason is that the issue before the court or before me as the referee judge was a right of appeal conferred by statute, right? And as you have read, I have noted 2 kinds of appeal and the jurisprudential aspect of it and the language of entry 3 of current list and so on and so forth. However, to translate this into practice and procedure as embodied in Article 191, in my view, would, and that is certainly not what this order was about, but would be incorrect. Why? For 2 reasons. One, because the subject matter of practice and procedure, insofar as law is concerned, you have told us that in your view it is limited, restricted, supervisory. It is not the entire breadth of the practice and procedure of the court. So if that is so, then no law which is so restricted, which is of a supervisory law-making capacity, which is restricted, supervisory, restrictive in nature, surely can confer a right of appeal in terms of that subject matter.
I
But
think it
secondly,
can.
there's just one more.
Yes.
Secondly, and more importantly, the subject matter, practice and procedure of the court is not restricted to the legislature. It is open even to the Supreme Court.
Yes.
It is primarily for the Supreme Court. So one conclusion that would follow from what you are saying is that the Supreme Court can itself create a right of appeal in exercise of practice and procedure. Is this what you are arguing?
My lord,
In relation to Section 5 now, we
My
are the
lord,
context
my
here
lord,
is Section
my
5.
lord.
So tomorrow, the full court amends the Supreme Court rules and creates a right of appeal. Can
my
it do
lord,
that?
my lord, I make two alternative arguments when it comes to the
Mr.
legislative importance
Mr.
of
Faisal,
appeal.
before
Ji,
going to
ji, ji.
answer the question of
Ji,
my lord,
ji.
please complete that page 18, para number 16 of my lord Hassan Rizvi. This is
Sorry?
very interesting para 16, page 18.
Para 16, sir. हाँ सर जी जी ये भी बहुत इंटरेस्टिंग है आई एम सॉरी दिस इज आल्सो क्रूशियल टू दिस मैं पेज 18 पे हूँ सर पैरा 16 it's very important that what Justice Hassan Rizvi has reminded us is very important to be reminded all the time. Paragraph 16. Surprisingly, this question, page 18, surprisingly, this question has also not been raised in this case, but it has been taken up by my learned brother on his own. The process of judicial scrutiny of legislative acts on the touchstone of the Constitution is technically called judicial review. The courts, however, should adopt judicial self-restraint in discharging their functions of judicial review in order to maintain harmony between the judiciary, the legislature, and the executive. The power of judicial review of legislative acts vested in the High Court, and this court must be exercised with freedom, wisdom and self-restraint, and not in a spirit of cold war between parliament or state legislature and the courts. Non-interference with the view of the majority in parliament with regard to what is reasonable and interference with what is prohibited by the Constitution may perhaps be a harmonious path for a peaceful transition for a glorious future. In Lahore Development Authority versus Mrs. Imran Tewana, 2015 SCMR 1739, this court, while stating the rules which must be applied to declare laws unconstitutional, has held that if a case can be decided on other or narrow grounds, the court will abstain from deciding the constitutional questions. So, my lord,
Sir Siddiqui, on a lighter note, if I may compliment you, what apparently were apparently divergent views, you have to reconcile all of them.
sir, I try to read everything which your lordships write,
Our
whether
bodies-
reported or unreported. Sir, now I'll come back to this, but my reading of your lordship's order is that if for the purposes of legislative competence, appeal is a part of procedural law. If that is so, then Parliament can also confer appeal.
Not all appeals, but intra-quota.
Intra-quota. 191 read with 58, and the court can also do that.
Court can also.
Yes, the court can also do that. Why is appeal not a restriction? I think an appeal against orders passed under 184(3) are not liberating, are not restrictive, they would be liberating, because it is a problem that there is no appeal against such tremendous power exercise.
This Order 5 Rule 2 that you read, even
Yes.
though we would certainly consider it as an administrative appeal, but practically it is an appeal provided it determines the right of the parties, and the rules are providing for that appeal.
Yes, yes. So this is one way I can, that legislative competence.
I've recorded your contention. Correct me if my understanding is correct. Intra-court appeal liberating, and both Supreme Court and Parliament can provide for them.
Yes, yes.
Okay.
Yes.
And why
They
did-
are not always restrictive, my lord.
If I may follow what my learned colleague has said with regard to Order 5, Why
I
didn't they
can't
use
hear
the
you.
word?
I can't hear you. I mean, I can't hear you. So
I'm so sorry. What my learned colleague said regarding Order 5, it's why do the rules use the word reconsider? Why not simply call it an appeal? Because read it, आप उसको पूरा पढ़िए ना, आप उसको kindly पढ़िए. There's a reason why it's called reconsider.
The power of the court in relation to the following matters may be exercised by a single judge sitting in chambers, but subject to reconsideration at the instance of an aggrieved party by a bench of not less than 3 judges, which may
include the judge who dealt with the matter.
Yes.
It cannot be an appeal. This is not an appeal because it cannot be an appeal.
So
If
this
it were
is a
an
review?
appeal, this is not
a
a review.
reconsideration.
This is a reconsideration.
Sir, it is like a review then.
No, it's not.
A review, practice and procedure में review का power confer कर दिया.
ये देखिए ना जी.
अगर
deliberately
in an appeal, can't a judge who passed an order sit?
Sir, that is not the notion of how things are.
I suppose he's one judge. I
Sir,
don't know. For instance, I'll just give you another example. A bench, their divergent views, right? And the matter is referred to the Chief Justice to send for opinion of the third judge. Alternatively, what could happen alternatively is because one set of arguments were, the third judge hasn't heard the arguments as were asked, or that particular question as articulated was not put to them.
Yes, yes.
So can the Chief Justice then say, can you all three sit together and decide it? Since now the possibility of a hung court will not arise. It can still go in 3 different ways. So what is that called? I mean, that option is available to the Chief Justice. I'm adding another member on the bench and hear this matter again, or whatever you want to call it.
And if I could add to that, if you look at Section 5, you see, I mean, this is a traditional notion, but if you look at Section 5 of the law, the one under challenge,
Yes,
it says that the appeal would go to a larger bench. Now, I just, want to understand whether a larger bench could have this earlier set of judges along with other judges, or a new set of judges as a larger bench. So, I mean, where is this restriction inherent? I mean, traditionally, yes, appeal would be heard by, but could there not be a hybrid system where there could be an appeal to a larger bench in this particular situation, which is the apex court dealing with these matters, and that sort of resolves the problem of 4 and 5 also? Why can't 1 or 2 other judges be added to it? I mean, is there a problem somewhere, or does it?
My lord,
is there
For instance, I'll just further add to it. There have been instances where review matters have come up before larger benches, even during the subsistence of the judges who had earlier passed the order, and they are reported cases. So what is that? Is it a classical review will be heard by the same judges? That's simple enough. Now, this matter has been decided by 2 or 5 or whatever, and 1 judge has been removed, 3 have been added. So that judge here, himself being bench, is reviewing the matter, and the others are exercising powers of appeal. Surely they can't be exercising powers of review. I don't know. So these, as his lordship, Mansoor Isha has pointed out, it may be a different category of animal.
Let me just build on what both your lordships have said. Let us forget about the distinction between appeal and review. Reconsideration.
That is only for the reconsideration, Mr. Faisal. You kindly read Rule 2, which says the reconsideration by the bench of 3 members. If you go through Rule 4, that is an application for reconsideration under Rule 2, and appeal under Rule 3. Appeal is an appeal live from the registrar in all cases to the judge in chambers.
So let us look at this word reconsideration.
2 parts of that. The reconsideration, that would not be considered an appeal, but the appeal is provided separately.
That is against
the order of the registrar in chamber.
That is
and
against
suppose if we were to consider Section 5 and
is why
consider it as a
the word-
reconsideration,
That is why the word reconsideration has been used, in which the judge who passed the order may be included in that bench.
Yes.
So it's not a part of appeal, it is not just like an appeal.
But let us see.
and if we were to just say that Section 5 is a reconsideration, and
Sir,
let's not
let-
in the word
Let's
appeal,
just
could it
focus
not
on
then
this
pass
word
muster?
reconsideration. What is happening? Sir, मैं एक बार
It is not an appeal, reconsidered.
लेकिन ये आप देखिए, ये जो रिव्यू एक्ट जो पास हुआ था इस एक्ट के बाद, उसमें लिखा गया था रिव्यू शैल बी हर्ड लाइक एन
मैं उस पे भी आ रहा था,
एंड उसके अंदर स्पीकिंग entirely for myself,
and it was struck down on
I have given
that.
a concurring judgment in which I have pointed out the serious jurisprudential issues that would arise where half the bench is essentially hearing it as a, because they've heard it before as review, and half the bench is hearing it for the first time, therefore an appeal. You can't mix and match like that.
Sir, let's forget about this distinction between appeal and
Constitution Constitution की distinction ही खत्म हो जाती है.
let us concentrate about the word reconsideration. Single judge ने order किया है, उसको reconsider कर रहे हैं 3 judges.
But that is on the administrative side, it's not
Sir,
the judicial
उसमें
order.
applications
Right.
decide हो रही हैं. अब reconsideration has become, which is in the nature
But
of a
all,
review.
all those matters in order 5, even though, well, it passes for whatever we may call it as a administrative, but the substantive rights being decided.
And they have been made a part of a law which is limited to practice and procedure.
But
So the
Parliament
word
is-
reconsideration.
Is it
Parliament
on
has called it an
administrative
appeal.
side, Mr. Faisal, or the appellate, or the judicial side?
Ji, sir?
Is this on the administrative side or the judicial side?
This is on the administrative side, sir.
Then why the word use agri party by a bench of not less than 3 members? The bench is constituted
Yeah, I don't know
The
if this
judicial
is.
side or the administrative side?
Taking that point further, I mean, whether at all these straight jackets about this administrative, moving into judicial,
The
moving
point
into
is-
administrative.
Probably the bard said it best. A rose by name would smell just as sweet.
I would
So
say-
whatever you call it,
I would say reconsideration and order of your brother judge on judicial applications, if that can be considered as a part of procedure and practice, my lord, then just building on what Justice Munib has said in his opinion, why not appease as a part of procedural law? So, but that's my alternative. But let me come to my main argument, which is legislative competence as far as appeals are concerned. I rely on entry 55. And like Hassan Azhar Saab's judgment, where he relies on 175(2), the judgment authored by her ladyship Aisha Malik Saiba has also relied on 175(2), read with entry 55 in the CCP judgment, which conferred an appeal to the Supreme Court. So,
See, as pointed out yesterday, there is a difference between bringing an appeal to the Supreme Court as opposed to creating an appeal against an order of the Supreme Court. So when you are relying on examples where the appeal is coming to the Supreme Court, it's different. The whole, the way of looking at the law and interpreting the law will be different. The question here is not about can this appeal come to the Supreme Court, it's about whether this appeal under 143 amounts to a creation of jurisdiction or whether it is the enlargement of the jurisdiction. I don't see how any of the issues that you are presenting have answered that particular question.
these are two separate
Mr.
questions.
Faisal, I mean, if the appeal comes through a statute or if the appeal comes through a statute like the Competition Act or the Elections Act or whatever, they are enlarging the jurisdiction of the Supreme Court.
That is
Either way, it goes directly into entry 55.
one of the questions which was raised by Justice Ejaz was that if you create a new appeal, is this enlargement or this is, because enlargement would imply something being there that is being enlarged. But your ladyship's judgment includes within the term enlargement in para 62 of the CCP judgment 2021 CLD, that enlargement in creation of a
can
new
you give me the
appeal.
citation too?
Ji. Sir, this is 2021 CLD 214 at para 62-64. But let me come back
Para 62.
to 64. But let me come to, there are two parts to the objection which have been raised. The first part is, where does legislative competence come from? Which end do you rely on? The second part is the problem which your ladyship has raised, which is, what is the constitutional procedure to be adopted to confer this appeal? Whether it's through an ordinary statute or through a constitutional amendment. Let me deal with both objections separately. Let me first come to the objection of legislative entry and legislative competence. If I may draw your lordship and ladyship's attention to entry 50, kindly It's quite a complicated entry. मैं अगर इसको जरा ब्रेक डाउन करके पढ़ लूं,
अगर आप पढ़ते हुए ये एंट्री 55 को एक दफा दोबारा से पढ़ें,
वही मैं पढ़ रहा हूं सर.
आप उसमें you miss out on the jurisdiction powers of all courts. What do you mean? What is excluded then? अगर हम आपकी बात माने तो फिर तो आप, क्योंकि उसका जिक्र कॉन्स्टिट्यूशन में हुआ है, तो आप उसकी हर चीज को इनलार्ज कर सकते हैं. वो आप बताएं, आप क्या समझते हैं इसके?
और दूसरा इसमें इसी सवाल में अगर पढ़ते हुए टू सच एक्सटेंट एज एक्सप्रेसली ऑथराइज,
जी,
इसके ये ऊपर के साथ पढ़ना है, नीचे के साथ पढ़ना है, कहाँ पढ़ना है?
Let us read this entry. Jurisdiction and powers of all courts except the Supreme Court. Now let me stop here. Your Lordship, Ladyship, may just keep your eye on the word jurisdiction and power, because it will occur again, but in a different form. With respect to any of the matters in this list. Now, this of course is not relevant, only to the extent that enlargement of jurisdiction and supplementary powers have to be understood by the first part. So it's a different thing which is being talked about in the second part when one is talking about the Supreme. Now,
और अंडर से पढ़े ना, और अंडर.
जी जी. And to such extent as expressly authorized by or under the Constitution. So this is the first condition, that if you want to legislate under this entry, then you need a conferment by or under the Constitution.
So is it your argument that this by or under would bring in item 58?
No, this is okay. Not. But there are two restrictions on this entry. It is not an open-ended entry.
So you're saying that this, to such extent as expressly authorized, is to be read on the first part of the entry relating to the high courts and other courts, or to the Supreme Court?
No, second
or
part.
both?
Second part.
Second part.
Yes.
Okay.
To the Supreme Court part.
Okay.
To such extent as is expressly authorized by or under the Constitution. Now you need to seek this conferment of power from other provisions of the Constitution, either expressed by or necessary implication. But that power,
55 में Mr. Faisal, ये जो दो लाइनें हैं ना, with respect to of the matters in the list, ये तो हो गया बाकी कोर्ट्स के लिए.
ये तो कोर्ट्स के लिए हो गया. ये हमारे लिए
जो शुरू हुआ वो फिर आगे सुप्रीम कोर्ट का तस्करा.
जी जी जी. अब सुप्रीम कोर्ट.
हाँ चल, इसके मानी पे एक्सटेंट के.
और इसमें जो express authorization, the words used are expressly authorized by the Constitution. Where do you get the express authorization from?
Yes.
Who explain
but
that?
It is by or under. That's critical.
No. You see, express means express.
No.
It can't be implied.
By
when it says express, then it has to be express.
I'll
you
explain.
Can't read implied
Let me just
into
explain
it.
the other two restrictions, and then I'll come back to this.
I am really enjoying your physical motions. It makes me a little dizzy, but I'm really
Sir,
refreshing
sorry,
also.
sir. I'm sorry.
No, it's okay. I mean, it's just on the lighter side.
If we stop him, we won't be able to argue.
No. I just find it very refreshing.
Sub Article 2. This is the only exercise I get, sir. Sir, the first restriction is the enlargement of the jurisdiction of the Supreme Court. Now, your Lordship will see the difference between the first part and the second part. You can't legislate in relation to all matters in any way when it comes to the Supreme Court. It must be, there is a restriction involved. You have to justify the law as enlarging the jurisdiction of the Supreme Court.
But expressly or
yes.
वो बताएं वो कहाँ है?
उसका क्या मानी है?
एक मिनट second part पढ़ लूं जी. And the conferring thereon supplementary powers. So it's not that you can legislate on any powers of relating to the Supreme Court. It should be a law that confers powers on the Supreme Court, supplementary.
In addition to what is already mentioned.
Ji?
In addition to what is already there.
Yes. So this is a way to protect the jurisdiction and the powers of the Supreme Court. That if the
Parliament दोनों है ना, एक तो enlargement का भी है.
निगरान वज़ीर-ए-आज़म अनवारुल हक काकड़ एक रोजा दौरे पर कोयटा पहुंच गए।